So about 3 years ago, we took over the management of a property from a client here that was local. And the property at the time we took it was occupied by a tenant. And so we said, hey, Mr. Owner, will you please send us a copy of the lease that you have with your tenant? So he said, sure, we'll send it right over, Daniel. So he sends me an email. I get the email, open it up, and it's a 5-page lease with, it looked like it was from Office Depot, purchased about 15 years ago. It had all sorts of scribbles on it, and they were doing math on one of the pages, and it was silly. It was ridiculous that this lease would exist. And leases are so critically important when it comes to managing rental properties and enforcing terms. And so don't be like this guy, okay? We ended up evicting that tenant that he had placed and signed this lease with. We ended up evicting that tenant for him, and it was a bad situation. It resulted in thousands of dollars of losses, and a lot of it was because of the lease that he had signed with his tenant. So leases is the topic of this video, and I want to know if you have these 10 important terms. But before I start, I want to give you two things that are the most important takeaways for this video. Number one is you have to be using an attorney-prepared lease. It's just not an option anymore. You're exposing yourself to a tremendous amount of liability by not using an attorney-prepared lease. So please use an attorney-prepared lease. And number two, the second thing I want you to learn is every year you need to update that lease. You need to contact your attorney and you need to update that lease. Ideally in July or August. That tends to be a good time because that's after the legislative sessions end and all the new laws are passed. Then your attorney can implement all the new things. So here we go. Here's 10 terms that I think are going to be important for you as you're managing your rental properties. The first is a cap on attorney's fees. So this is important because there's a growing trend of tenant rights attorneys who are out there who are pursuing jury trials for evictions and also class action lawsuits. And so it's highly recommended that you have a cap on attorney's fees built into your lease. It discourages those tenant rights attorneys from taking these cases and going after you. In addition to that, if you happen to lose in the trial, you know what your liability exposure is, right? You know what your monetary exposure is for those attorney fees. And then, it seems to be a good practice that our attorneys are recommending. So a cap on attorney's fees is number one. Number two is a holdover clause with built-in rent escalation. I love this clause a lot. We have used it a lot more recently due to some changes in legislation about just cause evictions and the timing in which those, I'll call it non-renewals of leases, but anyway, holdover clauses where the tenant remains in the property after the lease term expires. And what it does is our lease will automatically increase the rent by a certain dollar amount. So let me read. I have my lease here. It's 23 pages long, by the way. And here's the holdover clause. If after the lease term expires, tenant remains in possession of the premises and continues to pay rent without a written agreement as to possession, then the tenancy will be regarded as a month-to-month tenancy terminable upon 30 days written notice by tenant, with monthly rent payable in advance in the amount of the monthly rent due under this lease during the term, plus 20%. Okay? That's our provision. That's what we like to do. The reason is it kind of protects you in the event that the tenant does hold over after the lease term expires. And you can make the holdover rent increase whatever you feel is appropriate. We use 20%, seems to be a reasonable amount. That is number 2. Number 3 is warranty of habitability. This is actually a result. This is new for 2025. So there is specific verbiage that has to be in your lease, and not only does it have to be in your lease, but it has to be in 12-point font and bold font. So the law, it's actually written into the statute that this has to be written that way. So here's what it says. It all has to do with the warranty of habitability, which is a law that pertains to the condition of the property and certain maintenance and repair of the premises. So it says, every tenant is entitled to safe and healthy housing under Colorado's warranty of habitability, and a landlord is prohibited by law from retaliating against the tenant in any manner for reporting unsafe conditions in the tenant's residential premises, requesting repairs, or seeking to enjoy the tenant's right to safe and healthy housing. Whoa. So you have to have that specific verbiage in 12-point bold font in your lease. Not only that, but you have to have another additional notice about where the tenant can mail or deliver the written notice of an uninhabitable condition. So make sure that this is in your lease. If it's not, you are not compliant with Colorado law. This is new for January of 2025. Number 4 is some provisions about the retention or return of security deposits. The primary thing I want to communicate to you about this is the timing of the security deposit, okay? So Colorado law says that you have 30 days to return the security deposit with a statement to the tenant, unless the lease specifies a longer period, not to exceed 60 days. So take advantage of the 60-day rule. Give yourself some time to assess the condition of the property when the tenant moves out, get all the final repairs done, get all of the final utility bills, and then you can send the statement to the tenant and tell them what you have withheld from their security deposit. So our lease says any amount remaining from the security deposit, together with a written statement of accounting for any portion retained, will be returned by mail to the tenant not more than 60 days after the expiration of the term. The landlord will mail the return or accounting to tenant's last known address. There you go. Take advantage of the 60-day rule. Number 5 is late payments. Colorado law allows a landlord to collect late payments, $50 or 5% of the monthly rent amount, whichever is greater. So you are limited to those amounts, $50 or 5% of the rent amount, whichever is greater. And you can charge a late fee on after the rent is late for more than 7 days. So if your rent is due on the 1st of the month, then you can charge a late fee on the 9th of the month. So talk to your attorney about that, but ours has some very specific verbiage in our lease. So for example, if the rent is due on the 1st day of the month, rent must be received on or before the 8th day of the month, or a late fee will be charged on the 9th day of the month. So we spell it out pretty clearly for our tenants. Late payments is another clause that you need to have in your lease. Joint and several liability is really helpful for especially those landlords who are dealing in college rental properties, because it basically means that each tenant is separately liable under the terms of the lease. So our verbiage says, if more than one person comprises tenant, it is expressly understood and agreed that each person comprising tenant is jointly and severally liable for any and all obligations of tenant in this lease. This means that each and every person comprising tenant is, together and separately, responsible for all of tenant's obligations. If tenant violates the lease or rules, all persons comprising tenant are considered to have violated the lease. This is really important, especially on those college leases, joint and several liability. Subletting, assignment, and changes in occupancy. This is something I think that you should address. We do not allow any subletting or assignment of leases. So a subletting situation would be, I'm the landlord, I lease the property to you, and then you lease the property to someone else. And so we don't want that. It opens you up to too much liability as a landlord. We actually have some specific verbiage in our lease that even says that the tenant cannot advertise the property on any short-term rental advertising sites. That was a trend that we saw and continue to see from time to time and hear stories about from other landlords. So no subletting, no assignment of leases. And if you're going to have, if you're going to allow a change in occupancy where, for example, you've leased the property to someone and then they want to move out and someone else is going to move in, like roommate transfers, have a change in occupancy clause that requires that the tenant pay a fee for those situations, because it's a significant amount of work to move one of the people out of the house, move a new person in, and do all the background checks and all the paperwork and draft a new lease agreement. So there's a lot of work there that's involved. So have a change in occupancy clause and charge a fee for it. Number 8 is medical marijuana. So our lease has a strict no smoking clause, no illegal drugs or controlled substances, no smoking of any kind or nature, no marijuana in any form or of any nature shall be permitted on the premises or common areas, including but not limited to marijuana plants. So what we continue, there's an additional clause here that I'm going to read to you in a second. But this is a really important lease clause because in Colorado, there is the medical marijuana thing that goes on. And so here's what our lease says to address it. Colorado Amendment 20, also known as the Medical Use of Marijuana Act, is a law that permits the use of medical marijuana in specific and limited circumstances. The state of Colorado has also passed additional legislation in adopted rules that govern the use of medical marijuana, hereafter Colorado Medical Marijuana Law. Despite the Colorado Medical Marijuana Law, the Federal Controlled Substances Act categorizes marijuana as a Schedule I substance and further provides that the manufacture, distribution, or possession of marijuana is a federal criminal offense. Possession, use, and or cultivation of marijuana on the premises shall constitute a substantial default under this lease. So this is really important. Substantial defaults, by the way, are a separate type of default that you can sometimes use to expedite a legal eviction process. So having a medical marijuana clause in your lease is critically important, and I hope you add it. Delay in possession is another one that we really like. If you're dealing in new construction properties or maybe college rental properties where on new construction you don't always know when the property is going to be completed and move-in ready, or number 2, for college rental properties, sometimes those turnover periods are really fast between tenants. Delay in occupancy or delay in possession is a good clause for you as a landlord. Here's what ours says. If landlord is unable to deliver possession of the premises at the commencement of the term, tenant agrees that landlord shall not be liable for any damages caused by failing to deliver possession. And this lease shall remain in full force and effect, provided that there shall be an abatement of rent prorated on a daily basis. For each day there is a delay in delivery of possession. And tenant shall have the right to terminate this lease if landlord is unable to deliver possession of the premises on or before the date that is 5 business days after the commencement of the term. Tenant shall not be liable for any rent until possession is delivered. So it protects the landlord. It's a total inconvenience for the tenants, but you might consider adding a delay in possession clause to your lease. And number 10, add something about repair and maintenance. We tend to see some pretty common things that are either caused by most of the time are caused by the tenant. For example, clogged drains, garbage disposals, pest control, and broken glass. Those are a few really common things that we run into. And if you spell it out clearly in the lease, it takes away, any questions or rebuttals from the tenant about those situations. So spell it out clearly. interior drain lines are the responsibility of the tenant. Pest control after a certain period that the tenant takes possession is the tenant's responsibility. Broken glass of any kind in the property is the tenant's responsibility. So there are 10 terms that you should consider having in your lease. I hope it's helpful. If we can help more, please don't hesitate to call. I'm happy to help you and am available anytime. My phone number and email address are right here for you. Have a good one.